Assalamu alaikum. Good afternoon, everyone, and welcome to Theveli 2025 International Conference. My name is Fatma Halim, and I'll be your moderator for this session. This session is a 1-hour session with 40 minutes presentation by our keynote speaker and 20 minutes of question and answer session. So before I begin, first let me introduce our keynote speaker. It's my pleasure to introduce today's keynote speaker, His Honor Judge Malcolm Simmons, Judge of the Supreme Court of the Falkland Islands, South Georgia and South Sandwich Islands and British Antarctic Territory. His Honor Judge Malcolm Simmons is a UK qualified lawyer and judge. Currently, he is resident judge and His Majesty's Coroner of the Falkland Islands, South Georgia, South Sandwich Islands and the British Antarctic Territory. He is also a judge of the Supreme Court of St. Helena. Judge Simmons has served as an international judge for over 20 years. In 2004, he was appointed an international judge of the Court of Bosnia and Herzegovina, assigned to the War Crimes and Serious Organized Crime Panel. In 2008, he was appointed an international judge of the Supreme Court of Kosovo and presided in many war crimes and serious organized crimes cases. In 2014, he was appointed President of EU International Judges. Judge Simmons has also served on judicial councils in Bosnia and Herzegovina and Kosovo. In addition to his judicial role since 2017, Judge Simmons has been an international justice advisor and has worked in the Maldives, Pakistan, and Serbia. At the request of Maldives Judicial Academy, Judge Simmons assessed the judicial training curriculum and advised on reform of judicial training and developed training modules and materials. Most recently, Judge Simmons developed and rolled out a judicial performance evaluation scheme in the Maldives. In 2022, Judge Simmons was invited to lead the European Commission project supporting justice reform and anti-corruption in Maldives. Following the successful completion of the project, he was requested by the European External Action Service to assist in designing the EU's continuing engagement with the Maldives judiciary. Judge Simmons is a judicial trainer at the Judicial Education Institute and has delivered trainings across the Caribbean. Please join me in welcoming our keynote speaker, sir. Thank you.
Good. Thank you, everyone. I've obviously got the afternoon lunch slot, so I may have to lock the door so that nobody can actually leave. Now, the title of my presentation is Judicial Evolution and its Place in Contemporary Governance. In essence, I'm going to talk about separation of powers and the evolution of an independent judiciary. Now, why does separation of powers and judicial independence matter in the context of this discussion? The fact is that without separation of powers and an independent judiciary, some of what we are discussing here today would simply not be achievable. The separation of powers promotes good governance, ethical conduct, transparency, and accountability, creating an environment that embraces collaboration and individual exploration. An environment that promotes diverse perspectives, encourages learning and adaptation. An environment in which individuals feel empowered to contribute and take calculated risks that inform the evolution of ideas. Now, while my presentation is very much from the perspective of an English judge and lawyer, the principles apply equally across all jurisdictions and may resonate with some of you here today. Now, it's now 25 years since the Latimer House guidelines for the Commonwealth on good governance, on good practice governing relations between the executive, parliament, and the judiciary were introduced. The guidelines have since been revised and updated into their current iteration, which is the Commonwealth Principles on the Relationship between the three branches of government, or the Latimer House Principles for short. Those principles remain as relevant today as they have ever been. The principles are a set of guidelines established to promote good governance and the rule of law within the Commonwealth, particularly emphasizing the separation of powers among the executive, legislative, and judicial branches of government. The principles provide a roadmap for democracy and good governance by outlining how the three branches should interact and function independently. I will explore the meaning of separation of powers and its application to the judiciary in countries in the Commonwealth constitutional tradition. The institutional arrangements for the protection of judicial independence and the rule of law in most Commonwealth countries are similar to the arrangements that were broadly assumed to be in place in the United Kingdom. Now, many of you will be familiar with the concept of separation of powers. For those of you who are not, separation of powers is the division of the core functions of government, that's the legislature, executive, and judiciary, into separate branches to prevent the concentration of power in one institution or person. The division of power is designed to establish a system of checks and balances where each branch can limit the powers of the other. The doctrine of separation of powers is the product of centuries of political and philosophical evolution. Its origins can be traced to the 4th century CE, when Aristotle in his treatise Politics described three components of government, those being General Assembly, public officials, and judiciary. In Republican Rome, there was a similar system of public assemblies, Senate, and public officials, all operating on a system of checks and balances. Now, following the fall of the Roman Empire, Europe became fragmented into nation states, and from the end of the Middle Ages until the 18th century, the dominant governmental structure consisted of a concentrated power residing in hereditary rulers. There was no independent judiciary. The idea that a judge could frustrate the king's will was simply unimaginable. Now, I'm sure you've heard of Magna Carta, the Great Charter of 1215. This document significantly influenced the development of constitutional law and individual liberties in England and beyond. Now, some of you will undoubtedly be sitting there thinking, how on earth does a contract between an English king and English nobles more than 800 years ago have any relevance to the Maldives or indeed anywhere outside of England? Well, it has far more significance than you might think. What began with signatures on a document in the corner of a field in Runnymede in England was the birth of a political and social doctrine that would have profound implications across the globe. Now, we often celebrate Magna Carta as the foundation of an independent judiciary. However, there is not much support in the history of the 13th century for the view that judicial independence is the direct product of that famous document. In fact, in clause 45 of Magna Carta, the king said, "We will not make justices, constables, sheriffs, or bailiffs, save for those who know the law of the kingdom and wish to observe it well." In simple terms, that phrase means that appointments to positions of legal authority, like judges, law enforcement officers, and other officials responsible for enforcing the law, should only be given to individuals who possess a strong understanding of the law and a commitment to upholding it. It emphasizes the importance of competence and integrity in the legal system. Now, while that might support the desire for a properly educated judiciary, it would not have occurred to King John that he would not control his judiciary. The legislative, executive, and judicial authorities remained practically vested in the crown. Now, judges were, in the words of Francis Bacon, lions under the throne, upholding royal authority, in his words, being circumspect that they do not check or oppose any points of sovereignty. Yet, despite its practical shortcomings, Magna Carta represented the green sprouting shoots of legal constraint to government by the king, giving rise to what Thomas Bingham, a well-known English judge, has called the rule of law in embryo. There was one exception to the principle of power residing in hereditary rulers, and like Magna Carta, that was to emerge in the English Parliament in the 17th century. With the birth of Parliament, the theory of three branches of government re-emerged. Now, this was not the separation of powers that we recognize today. England in the 17th century had a monarch who retained considerable power. Instead, there was a dual form of government, and that was Parliament and the King. The branches were not co-equal, nor were they designed to operate independently. However, notwithstanding that, it is clear that the 17th century saw a significant shift of legal power away from the King and towards Parliament, and I will give you an example. Take the case of the Five Knights of 1627, also known as Darnell's case. The Crown demanded loans from a handful of knights to finance military operations. When the unwilling financiers refused to loan the money, they were imprisoned on the basis of His Majesty's special commandment. The king didn't need to give any other reason. The case highlighted the conflict between the king's supreme power and individual liberties. Although the Five Knights' appeal for habeas corpus was denied, the political result of their crown-mandated deprivation of liberty was significant. The disquiet from that case contributed to the passing into law of the Petition of Right in 1628. And clause, sorry, let me just go ahead. Clause 8. Okay, I found Clause 8. Clause 8 of the Petition of Rights provided that no man hereafter shall be compelled to make or yield any gift, loan, benevolence, tax, or such like charge without common consent by Act of Parliament, and that no free man in any such manner as is before mentioned be imprisoned or detained. So we see a gradual erosion of the monarch's supreme power. The doctrine of separation of powers was refined by Montesquieu, who based his theories on the English system. In essence, his was a preference for an independent judiciary and a greater distinction between the three branches of government. In expressing the importance of clear distinctions between the three branches of government, Montesquieu wrote, and I'm going to quote, "When the legislative and executive powers are united in the same person or in the same body of magistrates, there can be no liberty." He went on to say that again, there is no liberty if the power of judging be not separated from the legislative and executive branches or powers. Were it joined with the legislative, the life and liberty of the subject would be exposed to arbitrary control, for the judge would then be the legislator. Were it joined to the executive power, the judge might behave with all the violence of an oppressor. And it's probably the final paragraph that encapsulates the essence of his theory, which is there would be an end of everything were the same man or the same body, whether of the nobles or of the people, to exercise those three powers, that of enacting laws, that of executing the public resolutions, and that of judging the crimes or differences of individuals. Now, that was Montesquieu writing in 1748. 17 years later, Blackstone, in his commentaries, explained the importance of an independent judiciary when he said, were it joined with the legislative, the life, liberty, and property of the subject would be in the hands of arbitrary judges whose decisions would be then regulated only by their own opinions and not by any fundamental principles of law, which, though legislators may depart from, yet judges are bound to observe. So the great philosophers of the time clearly understood the dangers around a fusion of powers. Interestingly, in 1787, the American colonists relied upon the words of Montesquieu and Blackstone when drafting their new constitution. Now, American colonists had just fought a war with England and were keen to shed the monarchical shackles and to enjoy what they described as a new, more perfect union in which justice was to feature prominently. While the American colonists were implementing their own constitution, in Europe, France introduced its Declaration of the Rights of Man and the Citizen. That was in 1789. And this was first drafted by the Marquis de Lafayette. And although it is said to be based more on Rousseauian theories than those of Montesquieu, it nevertheless provided that all political association was to preserve the natural and imprescriptible rights of man. Lafayette went on to say, a society in which the observance of the law was not assured, nor the separation of powers defined, had no constitution at all. In other words, the establishment and maintenance of an effective justice system was a prerequisite of any properly functioning society. Now, there is one important English philosopher and theologian who is often forgotten, and that is William Paley. Just 2 years before the US Constitutional Convention, he wrote, "The judges of the land become not infrequently the arbitrators between the king and the people, on which account they ought to be independent of each other." Now, focusing for one moment longer on the United States, the leaders of the American Revolution featured a number of prominent lawyers who no doubt would have been versed in the legal and philosophical movement towards a clear separation of powers. Given that, perhaps unsurprisingly, Article 6 of the US Constitution was to provide that this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So thus the concept of separation of powers, including an independent judiciary, was born. These days we are rarely concerned with kings exercising unfettered power over those they rule. In Commonwealth countries in which the English monarch remains the head of state, his role in relation to the passing of statute is now almost entirely ceremonial. Most Commonwealth countries no longer have a monarch who wields supreme power. Therefore, when we talk today about judicial independence, we must ask ourselves, independence from whom? In view of its power over the judiciary, which it funds and whose judgments it enforces, the most obvious candidate against whom independence is asserted is the executive branch of government. However, it is important to recall that what is required is a system of mutual checks and balances that maintain an equilibrium between the three branches of government. Therefore, judges also need to act independently of parliamentarians, the media, pressure groups, and powerful individuals or corporations. And I mention this because currently in England, some politicians are asserting that judges have become more political and have entered the political fray. Now, undoubtedly, there was a judicial rise to political prominence that began during the late 1950s and 1960s with the arrival on the scene of a new and more confident generation of judges serving in the Court of Appeal and on the Judicial Committee of the House of Lords, the predecessor to today's Supreme Court. Whereas previous judicial generations have been brought up to believe that it was a British judge's duty to remain in the background and always, when in doubt, to defer to Parliament and ministers, many of the newcomers believed that citizens in a democracy had certain rights and that it was the court's duty to protect those rights, even if it meant overruling individual ministers and conceivably even Parliament itself. And I will return to this notion of overruling individual ministers when I touch on judicial review in a moment. Now, most written constitutions incorporate the doctrine of separation of powers. However, we must be cautious. Constitutional provisions usually comprise a skeleton upon which the executive puts the flesh. The constitutions of many undemocratic societies contain provisions that guarantee an independent judiciary and other notable provisions that guarantee justice and rule of law. Indeed, tyrannical leaders will often point to provisions in their constitution to support their assertion that their government is subject to appropriate checks and balances. Of course, these provisions are essentially redundant if the judiciary is not able to act independently, including when judging ministerial actions. The concept of separation of powers, as interpreted in most Western democracies, assumes that there are three categories of public power, legislative, executive, and judicial, that are vested in three distinct groups of institutions similarly described. In reality, the distinctions are often imprecise. It is also important when talking about separation of powers that we have in mind not only a judiciary that is distinct from the legislature and executive, but also the manner in which the three branches of government coexist and interact. Many autocratic regimes have a judiciary that is separate to the other branches of government, but independence cannot be merely formalistic, it must be functional. So to what extent could it be said that each branch of government is truly distinct and independent? First, every constitutional system that purports to be based on a separation of powers in fact provides, and this is done deliberately, for a system of checks and balances under which each institution impinges upon another and in turn is impinged upon. I would suggest that checks and balances prevent one branch encroaching on the other. Second, there has always been debate about precisely what separation means. Does it mean separation of institutions, thereby precluding overlapping membership, or separation of functions, in other words, empowering each institution to exercise the function for which it was created? In reality, however, these are not mutually exclusive options. Any system of separation of powers must involve at least a measure of both. Third, the degree of separation that such a doctrine requires. Complete separation is impossible. Whenever we're talking about separation of powers, its structure and how it might be achieved, the starting point is usually a consideration of its purpose. This is usually articulated as preventing the abuse of power through the concentration of power and enhancing the efficiency of government. In this respect, it might be argued that separation of powers assumes that each branch of government is particularly well equipped to exercise the functions assigned to it, thereby maintaining that finely balanced equilibrium. However, that is perhaps to misstate the reality. In the United Kingdom, the doctrine of separation of powers has been somewhat muted. And why do I say that? In the UK, the distinctions between each of the branches of government has historically been blurred. This is most obviously the case with the relationship between the legislature and the executive, famously described by Walter Bagehot as a fusion of powers. There was also the ancient office of Lord Chancellor, who as head of the judiciary had also been a senior member of the government cabinet. One might also look to the judiciary in the fact that until the creation of the UK Supreme Court in 2009, the Judicial Committee of the House of Lords was the UK's highest court. Now, the blurred constitutional position in the United Kingdom changed with the Constitutional Reform Act in 2005, to which I shall return shortly. So what are the minimum standards when it comes to an independent judiciary? I've already mentioned in the context of separation of powers the concepts of institutional and functional separation. In the context of the judiciary, it would obviously be useful to understand what is meant by those terms. Let's look at institutional separation first. One question that often arises is whether in their personal capacities judges can perform other public functions that are not judicial in character. This issue has generated much debate and is usually determined by reference to a standard of incompatibility and the purpose of protecting the perception of the independence of the courts. Members of the judiciary clearly have to be seen by the public to be independent, and their activities outside of their professional life can, for better or worse, play an important role in this perception. And I am thinking particularly of social media. And there are strict rules in England about how judges are permitted to engage on social media. However, when it comes to institutional separation, the principal area of concern is the interface between the judiciary and the other branches of government. That is not to suggest that the other branches of government do not have a role. Rather, it is about the degree of that interface and what is permissible and acceptable within the rubric of separation of power. Before advancing to consider particular examples, it's helpful to highlight that in England, the interface between the judiciary and government has received insulation through legislation. Section 3 of the Constitutional Reform Act which is entitled Guarantee of Continued Judicial Independence, provides the Lord Chancellor, other ministers of the Crown, and all with responsibility for matters relating to the judiciary or otherwise to the administration of justice must uphold the continued independence of the judiciary. Moreover, Section 3, subsection 5 sets out that the Lord Chancellor and other ministers of the Crown must not seek to influence particular judicial decisions through any special access to the judiciary. Despite this statutory footing laid down 20 years ago, areas of particular concern remain, and these include the selection and appointment of judges, remuneration, and court administration. These issues are as relevant to judges in the Maldives as they are to English judges. I want to look first at the selection and appointment of judges. There is occasionally confusion around terminology. Selection and appointment are quite different. In the UK, we have a Judicial Appointments Commission. However, the Judicial Appointments Commission does not, in fact, appoint judges. It selects them. In some Commonwealth jurisdictions, the law provides that judges are appointed by a governor. It does not follow that the governor must be involved in the selection of the judges. The two roles are quite distinct. Now, confusion around who selects and who appoints is usually the product of the relevant legislation being completely silent, often providing for one but not the other. Many of these provisions are in antiquated legislation that in Commonwealth countries were drafted in colonial times by administrators who were often not lawyers. The lack of clarity has caused much confusion and has resulted in members of the executive being involved in the selection of judges. The selection, appointment, and training of judges are critical. Judges should be selected by an independent and impartial institution that selects candidates based on knowledge, experience, and above all, competency. It is arguable that the need for judges of suitable knowledge, experience, and competency is even more important today than it was at the time of Magna Carta. As more and more cases progress through the court system, the law has fragmented into an increasing number of specialisms. Ensuring that courts, particularly the appellate courts, have suitable judges to justly determine complex points of law within these specialisms is vital. It has therefore become increasingly common to appoint judges almost directly from academic practice, and two examples being Lady Hale and Lord Burrows. In the Commonwealth, we have the Latimer House Guidelines that propose an independent process for the appointment of judges that will guarantee the quality and independence of mind of those selected for appointments. The Latimer House Guidelines further prescribe that appointments at all levels should be made on merit with appropriate provision for the progressive removal of gender imbalance and other historic factors of discrimination. If there is to be confidence in the selection process, it must also be transparent. Consideration should also be given to lay involvement in the selection process. For example, in the British Judicial Appointments Commission, there are special roles dedicated for non-legal tribunal members. The opportunity for lay involvement is important in making sure that the selection of judges is seen by the public to be independent and fair. Now, judges must also have security of tenure. In some jurisdictions, judges are appointed for life, while in others, it is for a fixed term. I am of the view that judges should be appointed until a retirement age prescribed in the law. This ensures that those who join the judiciary can do so for life, allowing judges to develop their judicial muscles throughout their careers, whilst also enabling the most competent judges to ascend through the hierarchy of the courts. When discussing security of tenure, inevitably we should also consider mechanisms to remove judges. While it might appear counterintuitive, this is critical to preserving an independent judiciary. And why do I say that? Confidence in the administration of justice is an essential element of preserving the independence of the judiciary. It is expected that judges will perform their judicial function competently and with diligence. Confidence is assured by a judiciary that adheres to a code of conduct and maintains standards of probity in their private as well as in their public lives. It is important that there are procedures in place to investigate alleged misconduct and, if appropriate, sanction or remove judges who fail to meet those standards. Of course, any process to investigate, discipline, or remove judges must be transparent, independent, and impartial. If it is not, the system is open to abuse. Those responsible for investigating misconduct must be independent. They must perform their function impartially. Those responsible for investigating misconduct must be independent of the body responsible for determining breaches of the judicial code. Above all, the process must be transparent. In many countries, a judicial council is responsible for regulating the judiciary. Some have the power to discipline and remove judges or to recommend to the legislature that a judge be removed. It is essential that judicial councils are, of course, free from political interference. In the United Kingdom, this insulation from political interference is preserved by the Act of Settlement of 1701, which protects judges against dismissal by the government without good cause.
Just 5 minutes remaining.
Okay, can I go over my time?
Sorry?
Can I go over my time? Can I go on? 15 minutes. Okay, I've just been told that I'm talking too much. I'm going to try and speed up. Okay, let me keep going. The beauty about being a judge is that everyone listens to you. Nobody. Well, I may be wrong on this occasion, but normally people do what you ask them to do. So that's my experience. Okay, I'm going to carry on. So regular judicial assessment and evaluation are also important processes to monitor the performance of judges and the effectiveness and efficiency of the administration of justice. These too should be independent, transparent, and impartial, lest they become a vehicle to unfairly criticize judges. Another important feature of judicial accountability that is often overlooked is the ability to review judicial decisions. The appeal process is an essential starting point, ensuring judges who make errors of law or procedure are corrected in a public forum. Appeal decisions often feed into judicial assessment programs. Judicial accountability is critical to a properly functioning judiciary. It is essential that the administration of justice is transparent. The public must have access to the courts in order to see justice being done. Judicial decisions and sentencing remarks should be publicized. The public should be given the opportunity to read and understand the judge's reasoning. There should be effective engagement with the media through informed court press officers. The introduction of cameras in courts also serves to increase transparency in judicial proceedings. Justice system must also be adequately financed and resourced. Most common law countries adopt the active settlement guarantee against a reduction of judicial salary while in office. While laudable in principle, it often fails to take account of inflation or the relativities between salaries of judges and other public office holders. In addition, issues often arise regarding the protection of other terms and conditions of judicial office. One of the big challenges for a truly independent judiciary has been the adequacy of judicial remuneration. Judicial salaries should strike a balance between presenting an independent profession and being sufficiently attractive as to ensure the judiciary obtains and maintains a diverse range of talented professionals. The risk of an inadequate judicial salary could see the bench fail to attract members in the first place, while also resulting in pre-existing members of the bench leaving the profession, perhaps to go into private practice. The adequacy of remuneration is a matter that lies almost entirely in the discretion of the government and parliament of the day, which does occasionally cause issues and tensions. These are important questions for both the independence and quality of the courts, but the provision of resources that control the control of public spending and the management of the economy lie properly with the other branches of government. Once again, a mediating principle that recognizes the responsibility of the elected branches while meeting the appropriate needs of the courts. Just very briefly mention that in some countries there is an independent body that regulates judicial salaries. In Australia, we've got the Government Remuneration Tribunal. This body is independent and determines the salaries to be awarded to federal office holders, including those within Parliament. The position in Canada is less clear, and in 2016, the British Columbia Judicial Compensation Commission recommended an 8.2% increase in judicial salaries. The Attorney General disagreed and proposed a cabinet resolution reducing the increase to 3.8%. That matter went for a judicial review, which was successful. But that, again, just demonstrates the tensions that often exist between the branches of government. And it's also worth pointing out that that particular case was about increasing judicial salaries. In principle, in my view, there is nothing wrong in times of austerity in reducing judicial salaries. However, and importantly, this must be an equivalent reduction across all sectors of government. It must not disproportionately impact the judiciary. I was going to talk about judicial training, but I know I don't have probably enough time. Court administration, I'm just going to be very, very quick, okay? Okay, I've got 10 more minutes. Court administration, it's equally important that the government adequately funds the justice system. Public funds should be made available for the provision and maintenance of court buildings, personnel, IT equipment, etc. This is an area of concern in some jurisdictions, particularly during periods of economic downturn when public funding is reduced. There's no doubt that it's also used occasionally as a tool to attack the judiciary, and then of course when the judiciary is unable to perform its function, it can occasionally give the executive an opportunity to then go to the public and say, we need to change things, we need to change the way the judiciary is operating. So we've seen that in various jurisdictions. In England, the Constitutional Reform Act sets out that the Lord Chancellor, in refraining from influencing particular judicial decisions, must have regard to the need for the judiciary to have the support necessary to enable them to exercise their functions. So there is legislative support for the executive supporting the proper financing of the judiciary. I'm just going to move on. I haven't dealt with functional separation yet. Let me just briefly deal with this. So we've looked at institutional separation. Let's look at functional separation. The oath that English judges take upon assuming office is to do right to all manner of people after the laws and usages of the realm, without fear or favour, affection or ill will. In other words, to decide cases impartially in accordance with the law. Judges determine cases based on law and within their judicial oath. There is no place within their judicial decision-making for their own personal or political views. In the United Kingdom, it's contrary to parliamentary convention for a minister to comment adversely on the judiciary or a court decision. That, of course, does not stop ministers commenting adversely on judges and judicial decisions. Currently, we have the Shadow Lord Chancellor who has made a number of comments about the judiciary. In 2003, the then UK Home Secretary David Blunkett, who was unhappy with the decision of a judge who had found against the government, said he was personally fed up with judges overturning the decisions of politicians, and that it is time for judges to learn their place. Now, there's nothing wrong in a government or a minister expressing disappointment at the outcome of a case and to express an intention to appeal. That is entirely acceptable. However, a UK minister referring to judges who issued a decision with which he disagreed as enemies of the people is clearly not acceptable. Now, while each of the three branches of government should refrain from encroaching on the other, the lines are occasionally somewhat blurred. And there is often dialogue between judges and the executive. It's not uncommon for judges to engage with politicians and civil servants on matters relating to the administration of justice. However, it is important that those contacts are not abused for any ulterior purpose and that the separation of powers is respected. To recall the words of the Latimer House principles, while dialogue between the judiciary and government may be desirable or appropriate, in no circumstances should such dialogue compromise judicial independence. I was going to look at judicial review, but we don't have time for that. But I'm happy in another forum to discuss judicial review, because it's very important. And those of you who don't know what judicial review is, it is about the ability of a judge to review a decision of a government minister. It's something that is exercised quite often in England, and there is provision in your constitution, I think it's in chapter 6, for judges in the Maldives to review decisions of ministers. But we can talk about that in another forum. So just in concluding, judicial independence is an integral part of the concept of rule of law that is the foundation of our democratic societies. It is the pillar to which other institutions of state are subject. It is the final check upon the exercise and potential abuse of unbridled power. Such is the importance of an independent judiciary in preserving justice and the rule of law that it is usually the first victim in the collapse of a democratic society. Even within democracies with established principles of justice and rule of law, challenges to judicial independence remain, and as a society, we must remain vigilant. There is no doubt that in many countries there are threats to judicial independence. Those threats may be the result of a rise of populism or innate in the structure of society or the system of government. Now, threats to justice exist everywhere. Attacks on the judiciary and the systems of justice are not confined to post-conflict societies or countries that have failed to embrace democratic principles. Such threats exist in the heart of Europe and in countries that for centuries have nurtured democratic institutions and established robust systems that fully embrace the most sacred principles of justice and rule of law. Confidence in the administration of justice is born out of trust in the judiciary. That trust is premised upon the principles to which I have referred. An independent judiciary is essential to preserving rule of law and the integrity of the justice system. But it is more than just judicial independence that is at stake. An independent judiciary is part of the system of government. The three branches are interdependent. If one fails, the essential equilibrium is lost. The entire system of government is undermined. Public trust and confidence in the democratic process is challenged, perhaps lost forever. Now, as I hope I've indicated throughout my speech, there are a range of threats to judicial independence. Some have existed for many decades, whilst others are features of modern society. Judicial independence, the separation of powers, and the rule of law are not concepts that are fixed in time. Our system of government must be responsive to modern threats, while also learning from mistakes that have been made in the past. Now, you have been very patient. I'm sorry that I talked for a very long time. I did try and stick to the script because I know that when I go off script, I can talk for much, much longer. Anyway, I hope that's been useful, interesting. Everyone is still awake, which is always a good sign. And I think there are going to be some, or there may be some questions. Maybe nobody has any questions, but I'm happy to try. Thank you.
Thank you, His Honor, Judge Simmons, for the insightful presentation. Now, we do have some time to open the floor for questions. So please kindly let me know if you have any questions. Yes, sir. I would kindly ask the participants to keep the questions brief because another session is due to start at 3 o'clock.
Okay.
Thank you. Sorry for this.
Thank you very much, moderator. And thank you very much, Honored Judge Malcolm Simmons from Falkland. It was a very interesting, enlightening tour you took us in explaining judicial accountability and independence, well, explaining the best principles and practices. I happen to sit sometimes back on the oversight body of the Maldives judiciary called Judicial Service Commission. And we certainly, as a budding democracy, has deficiencies, weaknesses, especially with like trust and confidence between even the three powers of the state. So we are in the process of learning still. And my question is, I wonder whether could we have the Commonwealth helping us to, support, build this trust and the judicial independence, like the process you have in Geneva, yes. Universal Periodic Review. Could we have such a similar exercise so that our government, our three branches, especially judicial branch, can be held accountable or give more support for yes. them to. So I wonder whether could there be any mechanism that could be built within the Commonwealth, because Commonwealth is the best defender and supporter of the small states in the world. Thank you.
Obviously, I can't speak for the Commonwealth, but I do have very good contacts within the Commonwealth, and I'm sure they would be delighted to start an engagement with you and with the JSC. And also there are other organizations, the Commonwealth Lawyers Association, they're very keen to be involved, and they have a lot of expertise in the region. And also the Commonwealth Magistrates and Judges Association would also probably wish to be involved. So there are a number of organizations with very eminent judges and academics who I'm sure would be very willing to engage with the JSC and others in terms of reform of processes or simply advising. Okay.
Thank you. Any other questions?
Just curious to see whether there are examples of kind of like charter cities even, where these sort of structures could be piloted, tested, experimented upon. Like, are there examples of it happening also? What are the ways to kind of simulate these sort of?
Could you please repeat the question?
Yep. I guess, what's the best ways to experiment upon these so that there's a lot of iteration done, so that maybe new models could emerge from the process? I guess, especially to kind of fit to hyper-localized contexts.
You're talking about other models that might improve what selection of judges?
The three powers kind of like in governance. Yeah.
Oh, so the separation of powers. Yeah. Okay. I mean, that is really the Commonwealth again. So the Commonwealth Secretariat, who I'm not part of the Commonwealth Secretariat, although the Commonwealth Lawyers Association, of which I am a council member, works very closely with the Commonwealth Secretariat, and I am in no doubt that the Commonwealth Secretariat would be delighted. That woke everyone up. I'm sure the Commonwealth Secretariat would be delighted to engage on separation of powers, because they were in part, the Commonwealth and the Commonwealth Lawyers Association together drafted the Latimer House principles. So there are plenty of people, myself included, who would be happy to engage in terms of, I suppose, training on separation of powers, be it with members of the executive, legislature, or judiciary. So again, we come back to the Commonwealth and the Commonwealth Lawyers Association. I will take this back when I go back to London. I will have a conversation with my colleagues and see what we can do.
Thank you, and thank you again. His Honor Judge Simmons. Simmons.
I'm not sure if that's a question. Probably not. I don't think so.
Maybe they need one more question.
Abdul, do you have a question? Okay. Fine, okay. Are there any other questions? In which case I will... Christian.
Yes, one last question, because we have another session at 3 o'clock.
Can you reflect on, in 30 seconds, about the very specific problems that you see in relationship to small islands or countries that have a population in less than a million?
Okay. I don't think I will have enough time. I mean, there are lots of different issues. I think in the Maldives, one of the big issues is access to justice, the fact that we obviously have a population spread over many, many islands over a very huge distance. And one of the issues we were talking about earlier was the fact that, for example, if you have cases involving, say, it's sexual gender-based violence or domestic violence, the implications of that are often quite huge, because you may have a wife, because it's normally a female who is the subject of domestic violence. She may live on an island a very long way from Mali, and she may have no resources in order to be able to travel to Mali. She may have children that she is responsible for. She may have no one to leave those children in the care of. She may have no money because her bank account may be operated by her husband. So access to justice for people like that is a huge problem. And of course, they cannot normally afford lawyers. Now, there are pro bono organizations that I know operate in the Maldives, but are really struggling to I think, cope with the number of referrals that they are receiving. And so, but in those cases where somebody is able to travel to Mali, what I have seen is that occasionally hearings are then adjourned. And of course, somebody having traveled, hundreds of miles at huge cost, relatively speaking, then cannot get into court. So I think that's one of the big issues here in the Maldives. One thing that does assist in that process is live link. So if you've got a remote court, which I am going to be talking about on Thursday for anyone who's interested, so where you have hearings over a video link, that is extremely useful. And then it does mean that people who otherwise would not have access to justice are able to access a court, albeit from 1,000 miles away. So there are measures that are in place. And so I think one of the big challenges is access to justice, but we know that there is a solution in the form of live link hearings. But of course, sometimes a live link isn't very effective because of the distance over which the link is operating, poor communication, etc. So, but it's something. But there are. I'm based down in the Falkland Islands, which is probably as remote as you can get. And we have other challenges down there, the very different challenges to the challenges that you have here. But and access to justice is an issue there, but not quite to the degree that it is here. But we have issues around live link as well. So I think if I had to take one thing, it would be access to justice and live links are two things that are fairly common across most small island states. Okay.
Thank you. Thank you again, Judge. His Honor, Judge Simmons, for the insightful presentation, and thank you, participants, for your engagement in this session. We hope you found it informative and inspiring as well. And lastly, before we close, I would like to invite our Vice Chancellor, Dr. Aishat Shehnaz Adam, to present a token of appreciation to His Honor Judge Simmons in recognition of their valuable contribution and generously sharing their knowledge and expertise with us today. Thank you so much.